Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to discuss the ramifications of the Violence Against Women Act and how it pertains to lift of conditionalities of U.S. immigration, specifically with an emphasis on U.S. immigration in the context of spousal visas. So what we're talking about here is there's another video which specifically discusses the differences between the IR1 and the CR1 visa. So the spouse of a United States citizen who goes to the United States married to a USC, that individual goes in, they enter in green card status and they take up their lawful permanent residence. In years past, they designed sort of a mechanism to try to thwart so-called marriages of convenience. This mechanism was called conditional permanent residence. Those not married more than 2 years at the time of the immigrant spouse's initial entry in the United States, those not married more than 2 years, that immigrant spouse was granted what was called conditional permanent residence, still is granted what's called conditional permanent residence. Conditional permanent residence basically is a 2-year period in which the green card status is granted, but it's for a 2-year sort of, for lack of a better term, call it a probationary period. 90 days prior to the 2-year anniversary of that individual's entry in the United States, the couple, generally, if the couple is still together, they need to go ahead and file to lift that foreign national's conditions. And when you lift conditions, it means that residence goes from conditional to unconditional. And once the residence is unconditional, then it is exactly what most people think of residence. They can live there, an individual can live there forever and basically receive a 10-year green card every 10 years, but the underlying residence is perpetual. Where this comes up with respect to the Violence Against Women Act is this 90 days prior to the 2-year anniversary, this filing for lift of conditions. There are situations in which foreign spouses are the subject of domestic abuse, and for that reason go ahead and divorce their American citizen spouses due to that factor in their relationship. And basically it was determined by Congress that essentially deporting those individuals who were subject to abuse, deporting those individuals was not particularly fair or equitable. And for that reason, Congress created the Violence Against Women Act, and one of the provisions of the Violence Against Women Act, I guess I should say the upshot of the Violence Against Women Act, is that that the foreign national spouse who's divorced an American citizen due to domestic abuse, domestic violence problems, can go ahead and self-file for lift of conditionality. So 90 days prior to that 2-year anniversary of the entry in the United States, if it can be shown that there in fact were domestic abuse issues, it may be possible for that individual to go ahead and self-file a VAWA petition to go ahead and get into unconditional permanent residence, notwithstanding the fact that the marriage itself did not last the normal prerequisite of 2 years in order to get the conditionality lifted. So it's sort of like a remedy created by Congress, basically to allow foreign national spouses to get out of violent relationships, violent marriages, abusive relationships without compromising their immigration status.